and I'm the Commission's designated presiding officer for this hearing. Today is February 4th, 2025, and it's approximately 10 a.m. And this is the date and time that's scheduled for the hearing on the settlement stipulation between Enbridge Gas and the Utah Department of Public Utilities in Docket 24-057-13, which is the application of Enbridge Gas Utah to extend service to Portage, Portage, Utah. Everyone in the right place? Great. Let's start with appearances for the applicant.
Thank you so much. My name is Jennifer Clark, and I'm counsel for Enbridge Gas Utah. And I have with me Austin Summers. He'll be speaking on behalf of the company and in favor of the settlement stipulation. We also have with us Will Radford and Tom Dixon, who submitted pre-filed direct testimony. They're available if questions arise that would require their expertise or their involvement. And Mayor Max Huggins is available by phone for the same reason. He also submitted pre-filed direct testimony.
Great, thank you. Let me just clarify. So Mr. Summers, you anticipate will be your only witness, subject to questions from the division or from me?
That's correct.
Great, thank you. And for the division?
Good morning. Patricia E. Schmid with the Utah Attorney General's Office on behalf of the division. The division's witness is Eric Orton, and he will be testifying in support of the stipulation.
Thank you very much. And my understanding from the stipulation itself is that the Office of Consumer Services is not a party to this, but they have, or it has authorized the division and Enbridge to represent that it, the OCS, doesn't oppose the terms agreed upon in that stipulation. Is that still the status?
Correct, yes.
Okay, and I'll get your witnesses to testify to that under oath. The last thing is confidential information. Sorry, the last thing. I have a preliminary list in my head. The last item on my preliminary items list is confidential information. Are we going to be able to do this in a way that we don't need to disclose confidential information?
Mr. Summers has prepared a summary that does not include confidential information and provided again that questions on cross-examination don't call any of that into question. We don't think it would be necessary to go into a confidential session.
Thank you. Ms. Schmidt?
Similarly, Mr. Orton has prepared a summary that does not contain any confidential information, and as with Enbridge, we do not anticipate he will need to address confidential information unless it is in response to a question.
Okay, thank you. I'll try to keep my questions non-confidential, if I have any. Okay, well, why don't we start? Ms. Clark, if you'd like to call your first witness, please.
I wonder if we could address one more preliminary matter.
Sure, yes.
Thank you. Paragraph 16 of the settlement stipulation indicates that both parties agree that all of the pre-filed testimony in the application may be admitted as evidence. And so I would move jointly with the division for the admission of the application and accompanying exhibits, and also Mr. Orton's testimony and accompanying exhibits.
Okay, so I just heard your motion was to admit, in essence, all the previous filings into evidence?
Correct.
Which would also include the division, since
Yes.
it's a joint motion. Since no one can object, your motion is granted.
Thank you.
Do you want to do the settlement stipulation do you want to admit that
Yeah,
as well?
let's move to admit that as well. Yeah, thank you.
Okay. I guess that was a previous filing, okay.
Yeah.
All right, everything is in. Thank you.
Thank
Please
you so
proceed.
much. Thanks. The company calls Austin Summers.
Good morning, Mr. Summers.
Good morning. Do you want me down here? Do you want
Yeah,
me?
why don't you come on up?
Okay. Good morning again.
Good morning again. Get comfortable. Just joking. Do you swear to tell the truth?
Yes, I do.
Thank you very much. You're sworn. Please proceed.
Thank you. Mr. Summers, will you please state your name and business address for the record?
Yes, my name is Austin Summers. My business address is 333 South State Street, Salt Lake City, Utah.
And are you the same Austin Summers who submitted pre-filed direct testimony in this docket?
Yes.
And was the application in this docket prepared by you or under your direction?
Yes, it was.
Mr. Summers, can you please summarize the stipulation in this matter and also the relief the company seeks?
Yes. Good morning, Mr. Delaney. I appreciate your time today. Before I begin, I just wanted to take a minute to thank the staff at the Division of Public Utilities for its help and its feedback in making this settlement happen. In this docket, Enbridge Gas seeks commission approval to expand to the rural community of Portage. Though this would be new infrastructure in a new rural community, the resource decision is nothing more than a continuation of the program that was approved in the Eureka, Goshen, Green River, and Genola dockets. The financial effect of this expansion on a typical customer using 70 decatherms would be about $1 per year, or 0.15%. But to be clear, that increase will not affect customers until the project is complete and the company seeks rate recovery. The application and accompanying testimony provided all of the evidence required to support approval of the resource decision. In my pre-filed direct testimony, I addressed the evidentiary requirements for the resource decision, discussed how and why the company chose Portage as the next expansion location, explained how many customers are expected to participate, how costs would be recovered, and provided other relevant financial and operational information. Mr. Radford's testimony explains the scope of the project, the construction schedule, the cost of the project, and the geographic results of the company's interest in natural gas. Related to Mr. Radford's testimony, in the technical conference, there was discussion regarding the route that the high-pressure line would follow. As discussed in the technical conference, each routing alternative has its own challenges. The company continues to work through those challenges, and we request today the route described in the application and Mr. Radford's testimony. However, we recognize that an alternative route may ultimately prove most prudent. We therefore request the Commission's approval of the project as set forth in the application, but recognize that we may return with a request for an order to proceed pursuant to Utah Code annotated section 54-17-404 with an alternate route. Now, regardless of the routing selection, we are confident that we can complete the project within the budget provided in the application. Mr. Dixon's testimony discussed the process of converting appliances to natural gas, the disposal of propane equipment, and the safety benefits of being an Enbridge Gas customer. Finally, Mayor Huggins described the community growth in Portage, the benefits natural gas would bring to his community, and he explained his support of this project. Taken together, the evidence provided shows that the resource decision is just and reasonable in result, and that approval of the application is in the public interest. The settlement stipulation largely accepts the company's proposal as filed. There are a few additional provisions, and so I'm going to draw your attention to paragraphs 6 through 10 of the settlement stipulation for those additional provisions. Paragraph 6 states that Enbridge Gas should be authorized to construct the facilities proposed in the application to serve the community of Portage. Paragraph 7 explains that the costs of the expansion will be collected through the Rural Expansion Rate Adjustment Tracker that is contained in section 9.02 of the tariff. Paragraph 8 provides that the company will file a copy of the permits, the franchise agreement, and other similar items with the Commission once they are finalized and executed. Paragraph 9 states that if the costs of the resource decision exceed the estimates provided in the testimony of Mr. Radford, the company will seek Commission approval of the excess costs prior to including those costs in the tracker. Approval of any increase will be subject to the statutory spending caps discussed in my direct testimony. Finally, paragraph 10 states that the company will work with Portage to ensure that appliance inspections by Box Elder County are occurring before a meter is set. Based on the evidence in the record and the stipulation of the parties in this docket, the company requests approval of the settlement stipulation. The company stands ready to start construction upon Commission approval. And that concludes my summary.
Mr. Summers is now available for cross-examination and the hearing officer's questions.
Thank you. Ms. Schmidt, questions for Mr. Summers?
No questions, thank you.
Thank you. Just a few questions. Mr. Summers, I think you can testify to this, but can you affirm that the Office of Consumer Services is not opposed to this settlement stipulation and has authorized its execution?
Yes, I can confirm that. As we were developing the settlement stipulation, we did provide that to the Office of Consumer Services, asked for their affirmation that they were not opposed to that settlement stipulation.
Thank you very much. With respect to paragraph 10 of the settlement stipulation, I think your summary of Mr. Radford's testimony may have hit on this, but I'll just have you repeat it, maybe flesh it out a little bit. So the parties agree for purposes of the settlement that the company will work with Portage to confirm that Box Elder County will be inspecting all the appliances. The sentence continues. I'm going to stop there. Well, so work with, what is it specifically that Enbridge Gas is going to be doing in this work with?
Yeah, and oddly enough, I in prior roles in the early 2000s worked in the meter set department. So oddly enough, that comes into play. Never thought I would say that, but when we work with the communities, we actually have them file a clearance with us. So the inspector will go out, they will inspect all of the appliances, the venting, everything, make sure everything is set up appropriately, safely, and then they will, the inspector will provide what we would call a clearance to Enbridge Gas. So we're working with them to make sure that it's, that we've received that before we will set a meter on the home.
Okay, thank you. So your testimony also mentioned a possibility of, and this is my characterization, an alternate route. And if such was encountered, there would be an order to proceed that would be filed. Was that an accurate summary?
That's correct, yes.
Okay. Is that concept anywhere expressed in the settlement agreement itself? And if so, where?
It is not expressed in the settlement agreement. It was something that we discussed a little bit at the technical conference about there being a, that each route that we've got has its own struggles or challenges, I guess, that need to be overcome. And as they're working through those challenges, they're looking at, is there an alternate route or maybe a combination of routes that we can use to get there. They're still working through those and haven't come to anything solid yet. And that was the case also when we filed the settlement stipulation. So there's nothing in there that says anything about the alternate route or that we would come in and file for an order to proceed. But we are acknowledging that if that does happen, there is a change, then we would certainly file for an order to proceed. I think the important thing there too is, as they're looking at those different routing options, that there's nothing there that would cause an increase in cost. So when we're looking at those routes, I think we could still keep it under the budget that we've requested in the application.
Okay, thank you. And I guess that's going to answer my final question on that point, which is not that you need to have this in the settlement agreement. I don't think you need a settlement agreement to have a basis to file an order to proceed. But is it something that you think should have been or should be in the settlement agreement? I'm going to ask the same question of the division, but so whatever your answer is, there's no correct answer.
And I think it's a good question. And I think that if we had, if we were far enough down the road when we filed the settlement stipulation, that we had known, exactly what route we were going to take, maybe I'm saying, yes, I think it could have been. Maybe I'll say it should have been in the settlement stipulation, but it also kind of, I don't know that it had to be,
Okay,
if that makes sense.
that's okay. So I'm just going to restate what I think I just heard you say is maybe, but it's okay that it's not.
Right.
Okay.
That's correct.
All right. Okay, last question. So granting this application, is it your testimony that that's in the public interest and that it's just and reasonable?
Yes,
Okay, thank you very much. If you said that and I missed it, I apologize.
not a problem.
Okay, that's all I have.
Okay, thank you.
Thank you.
The company has nothing further.
Thank you. Ms. Schmidt.
The division would like to call Mr. Eric Orton as its witness. May he please be sworn?
Yes. Good morning again, Mr. Orton.
Good morning, Mr. Chairman.
Do you swear to tell the truth?
Yes, sir, I do.
Okay, please proceed.
Good morning.
Good morning.
Could you please state and spell your name for the record?
My name is Eric Orton, that's E-R-I-C-O-R-T-O-N.
Are you employed by the Division of Public Utilities? And is 160 East, 300 South, 4th floor your business address?
Exactly.
And you have participated in this docket on behalf of the division?
I have.
Did you prepare or participate in the preparation and filing of your direct testimony 1.0 DIR with exhibits 1.1 and 1.2?
That's right.
Did you participate in the settlement discussions and preparation of the settlement agreement in this docket?
I did.
Do you have a summary to share with us today?
I do.
Please proceed.
Thank you. In this docket, the company is asking for the commission to approve its plans to extend its service to the currently unserved area of Portage, Utah, and allow it to recover the costs associated with this rural expansion through the Rural Expansion Rate Adjustment Tracker, as found in Section 90.02 of its tariff. The Utah State Legislature passed House Bill 422, which amended existing law to allow natural gas service to be extended to rural communities in Utah by having all the utilities' current customers share the costs associated with this rural system, and with certain limitations as set forth in Utah Code and associated commission rules. This settlement stipulation is sufficient to meet these statutory code and commission rule requirements. The division supports the extension of natural gas service to rural communities in principle, provided there is sufficient evidence to substantiate the extension and costs are justified and reasonable. However, it does need to be emphasized that the company still carries the burden of proof of just and reasonable rates based on substantial evidence for all costs it seeks to recover from ratepayers, including rural expansion costs. As a result of the division's review of the company's application and associated information it provided in this case, the division filed its direct testimony with the commission on November 21st, 2024, recommending approval assuming certain conditions were met. The company and division engaged in settlement discussions and negotiations where the division's conditions were discussed and adequately resolved. This resulted in the settlement stipulation submitted to the Commission on January 9th, 2025, and is at issue here today. This stipulation is very similar to past rural expansion stipulations approved by the Commission. The division's position is that this stipulation satisfies the necessary requirements under the applicable statutes and rules pertaining to rural expansion. This extension to Portage could be a benefit to that community and would not create a significant negative impact on the utility or its current customers. The division recommends that the commission approve the settlement stipulation as it is just reasonable in result and will allow the company to extend natural gas service to the area of Portage. That concludes my summary. Thank you.
Mr. Orton, just one question. Do you believe that it would be in the public interest for the commission to approve the settlement as presented?
Yes.
Thank you. With that, Mr. Orton is now available for cross-examination questions and questions from the hearing officer.
Thank you. Ms. Clark, any questions?
I have no questions, thanks.
Thank you. Mr. Orton, just a couple of questions. Will you confirm, can you confirm that the OCS does not oppose the terms agreed upon in this stipulation?
Yes.
Thank you. I'd also like to ask you about, well, you were here when Mr. Summers on behalf of Enbridge was testifying, right?
I was.
Okay, and did you hear his testimony?
I did.
Okay. I asked him a question about paragraph 10 of the stipulation, which deals with Enbridge working with Box Elder County. Do you remember that question?
I do, yes.
And you heard Mr. Summers' answer, correct?
I did.
Do you disagree or have anything to add? Do you disagree with Mr. Summers' answer or have anything to add to my question on that point?
I do not disagree with what he says. I also believe that the company will collaborate with and correlate efforts with the local governments, not only to inspect the appliances, but through the whole process of permitting and construction of the pipes, as well as installing the meters and that sort of thing. So I think those, I wanted to elaborate on what Mr. Summers said. There will be more cooperative work than setting the meters at people's homes. And we, on a regular basis, meet with the company as they're going through these rural expansions to get updates and find out. And so if in our mind anything is amiss in that sort of working with parameter, we'd either address it with them, or if that didn't work out, we'd come to you.
Okay. Thank you for that expansion of the answer. I think it gives me the information I need. Thank you.
Good. You're welcome.
Finally, Mr. Summers testified about the potential of needing to file an order to proceed. Do you recall that line of questioning?
I do.
And his testimony was that that notion is nowhere reflected in the settlement agreement. Do you agree with that?
I agree.
Okay. And do you, on behalf of DPU, have a position that differs from Mr. Summers, which was, while it could have been in the settlement agreement, it need not be in the settlement agreement? Do you agree with that?
I agree. Yes.
Did you want to, if you want to say more, please feel free.
I don't know that the route is issue here. Going over budget would be an issue, but the route the company chooses is up to them and their engineers, as long as we stay in budget, and that was the purpose of paragraph 10.
Or at least a paragraph
At
somewhere.
least a paragraph, that's true. I'm not,
Yeah,
yes.
okay.
The big point was the budget, not the route.
Yeah, and Mr. Summers' summary certainly addressed that point, correct?
Yes.
Okay, and the testimony submitted with the verified application also addresses that budgetary point, correct?
Yes.
Okay. Okay, that's all I have. Thank you.
Thank you.
Okay, I believe that's everything we need for this hearing. Anyone disagree?
No, thank you.
Okay, wonderful. Just double checking, is it everyone's understanding that March 19 is the is the expected deadline? I believe that's the
I
statutory.
believe so, yeah.
Okay. Anyone
Just
disagree?
looking for the signature line on the application, making
Okay.
sure.
Well, I'm hopeful, of course, that an order will be issued well before then. I just wanted to double check. I want to thank the mayor, if he's still on the line, for participating, for being willing to participate today. So thanks for attending. Thanks for everyone's preparation and the work you did in advance of this hearing. Thanks for your preparation reflected in the hearing today. And thanks for your patience with my questions. We will be adjourned. Thank you.
Thank you.
Thank you.